The times have changed, so has the delivery of news. We believe local news needs to be easily accessible. Hey, Owensboro, get with the times. Subscribe today at owensborotimes.com.
Hello, everyone, and welcome to the Owensboro Times 2022 General Election Town Hall, sponsored by Jerry Ray Davis, Chrysler Dodge Jeep Ram. I'm Jake Boswell. I'll be moderating this third of 8 sessions of this town hall today. For this session, we'll be joined by the 2 candidates for circuit judge. Candidates in this session will have 60 seconds to answer each question. They'll also get an additional 60 seconds for a closing statement. We'll go ahead and introduce our candidates, and we'll get right to the first question. We have Jay A. Wethington and Leigh A. Jackson. Our first question, after a random draw, will go to you, Mr. Wethington. And the first question has to do with a circuit judge presiding over a wide range of cases. What qualifies you to preside over those cases in these areas?
Well, I've been the circuit judge and the chief circuit judge here in Davis County since 2007. I have adjudicated all of the cases and the majority of cases that have been brought to the circuit court, and I have been doing that consistently and regularly since 2007.
Ms. Jackson, same question to you.
Thank you, Jake. I've been with the Public Defender's Office now for the last 13 years, but I've been an attorney in the Commonwealth for 22 years. In addition to practicing criminal law in the Public Defender's Office, I was in private practice for 5 years, handling different types of civil cases from defense work to plaintiff's work. So I understand both the civil and criminal sides of the circuit position. Uniquely, though, my experience as a public defender, I work in the trenches every day. I'm in court or at the jail or in prisons. Work closely with community providers, law enforcement, and others. So while I haven't had the opportunity to preside as a judge, I do have 22 years of experience to offer to the voters and the people of Davis County.
Ms. Jackson, you'll get the chance to answer the second question first. What methods would you suggest to improve court procedures and efficiencies?
We've had the unique opportunity to have hybrid court since the pandemic. We had to change over very quickly from 100% in-person to 100% virtual court. I worked very hard and closely with clerks and court personnel, the jail, deputies at the jail, and I think there's certainly a place for virtual court. We have inmates now spread out all over the state using virtual court proceedings, especially for resets and things like that. I think keeping that hybrid option open, but trying to return to in-person court as much as possible is important so that people can have their day in court. I think using virtual court for civil proceedings is definitely an option as well because the attorneys are able to appear from their offices or virtually with their clients.
Mr. Wethington, same question.
Well, when at the advent of COVID across the Commonwealth, we implemented remote hearings in all proceedings. And those remote hearings were restricted at the beginning. When I left, I was one of the members of the Circuit Judges Association, and I was leading the inquiry for all of my colleagues across the state to have the Supreme Court give us some rules for remote hearings because they have been an invaluable service not only to the court system, but to the public. Because we've had remote hearings, the public has been able to participate without coming to court and being intimidated. It's been particularly beneficial for victims who now have the right to come and participate in these proceedings, and that is going to continue. We have learned that remote proceedings has saved the taxpayers millions of dollars, and with my leadership, I'm going to continue to lead the inquiry to have the Supreme Court give all the circuit judges rules for remote proceedings.
This next question has a little bit to do with the efficiencies how the court will run as well. And this is your chance to answer first, Mr. Wethington. Some cases, particularly those involving murder charges, have drawn out over the last few years. Just last week, there was a case from 2017. And what, if anything, can be done to get a case like that or those cases moved through more quickly?
Well, our rules of ethics prohibit us from commenting on any pending cases or cases that are going to be brought, that we have reasonable grounds to believe that are going to be brought in front of us. As Ms. Jackson knows, the paramount concern about any serious case in circuit court is the due process and the protection of the rights of the defendant. In a serious case, those rights are extended. They need to have all the time they need to prepare for trial, as does the Commonwealth. The Commonwealth also has certain rights to present their case in a reasonable fashion, but most particularly the difficult cases require extensive work by both sides, and you have to give them time to do that.
Ms. Jackson, same question.
I would agree that, of course, in a murder case, there are more extended practices that we have to participate in. The process is just longer, as it should be. Whether there is a death notice or not, murder is a capital case, capital charge. I would say, though, that with remote proceedings, particularly defense attorneys are carrying a heavy burden. The processes of handling cases are very different. Multiple trips to the jail. There are hurdles that defense attorneys, whether public defenders or private bar, face now if clients are not brought to court. So trying to get back to in-person court is important, but again, you can't rush the process. Patience is important in making sure that both sides have all the time they need to handle their case and prepare their case adequately is the most important concern.
And this next question is one we'll ask almost every candidate who comes out on stage this evening. Give 1 second to pause here for technical support. So I'll go ahead and restate. The next question we have is something we'll ask almost every candidate who's on stage tonight, no matter their position. And Ms. Jackson, you'll get the chance to answer this one first. Juvenile crime has risen over the last year. What's the role of the court in helping reduce the number of repeat juvenile offenders?
As a circuit judge, I would only see the juveniles that are transferred and to be tried as adults. Unfortunately, we are seeing more gun crime in our community. That is in part connected with drug use and drug trafficking. Utilizing any and all opportunities for community programming, mentorship, counseling services, trying to provide youth with alternatives to being on the street and influenced by negative peers and negative mentors. Kids who don't have strong role models at home and don't have their mental health issues addressed, their needs addressed, and things to do, fall prey to people who are negative influences in their lives. The court can simply utilize any and all alternatives out there, from detention to counseling to other programming.
Mr. Wethington, your chance to answer.
Unfortunately, by the time a juvenile gets to circuit court, it's like calling the fire department. The house is already on fire. When the juvenile gets to circuit court, it's only because they've engaged in serious, or the allegation is that they've engaged in serious criminal activity. Nevertheless, their rights are, as juveniles, need to be protected. Their rights are protected. They are housed separately from adults. And the Cabinet for Juvenile Justice, who mentors and counsels and oversees their housing if they remain in custody, has been very good at giving the courts some advice, some much needed insight in what's the best prospect for this child not to engage in criminal behavior, or what's the worst. They give us both sides. So we rely on the Cabinet for Juvenile Justice, who are in weekly and sometimes daily contact with juveniles who are accused of serious criminal offenses.
Let's move on to our fifth question now. I'll give you guys a chance to think about this one. And Mr. Wethington, you'll get the first chance to answer. Along the lines of repeat offenders, as we've been kind of talking about, some people show an escalating degree of offenses, working their way up from misdemeanors to felonies. That includes assault, even murder in some cases. What role does the court have in helping identify individuals and maybe intervening before they get to the point where they're escalating to more serious offenses?
Well, what we have when a person first appears in court, we have a pretrial list of it lists their prior criminal history, it lists their family history, their education, their health history. We have that same information before we sentence an individual. So that information is very helpful and those are some of the hardest decisions that I've made. How do you predict, future criminal activity? Well, the best prediction of how somebody is going to perform is how they have performed in the past. That's particularly instructive to me is when I'm being asked to release somebody that has not been convicted yet, but they have demonstrated that they are continually going to be involved in criminal activity, and most importantly, they have violated court orders on release. So we rely on that information, and those are very difficult decisions.
Ms. Jackson, I'll restate it for you, at least a piece of the question before you answer. What role do you think the court has in helping identify individuals and intervening before they escalate from minor offenses to more serious offenses?
Circuit court deals with felony cases only from the criminal perspective. So we don't have the opportunity to intervene when someone hasn't reached that level. That being said, I agree, looking at their past behavior is important. Looking at opportunities they've had. Have they had an opportunity to get the mental health counseling, the substance abuse assessment and treatment, an opportunity to have a probation or parole officer to provide support and help them to get services that they need. I think identifying those things, even at the circuit level, is important. And those are factors that must be considered in determining what to do when sentencing someone, or even pretrial, if we're asked to release them to a counseling program or to other alternatives to detention. Identifying the risk factors and knowing and having a working knowledge of the different services that are available.
Let's move along to our sixth question. Ms. Jackson, you get the chance to answer this one first. And do you think that there should be any judicial reform for those who are given lengthy sentences for maybe nonviolent crimes or have shown good behavior while incarcerated?
I think that there's already a built-in filter for those that aren't violent. We have violent offender statutes that require 85% service of a sentence before you're parole eligible if you commit a violent offense. Now, I will note there are some offenses that are violent under the statute that don't appear to be violent on their face. I do note that the fentanyl statutes are now requiring a mandatory minimum sentence, but that is because fentanyl has become a plague in our community. Nearly all street drugs we know now have some level of fentanyl potentially in them. So it's dangerous and inherently nonviolent, but dangerous nonetheless. So I think the legislature is doing what they need to do to try to protect the people of the Commonwealth.
Mr. Wethington, same question. Do you think that there should be any judicial reform for those who are given lengthy sentences for nonviolent crimes or have shown good behavior while they've been incarcerated?
That's an interesting question. The federal government tried, what you're asking, I think, is statutory or mandatory sentencing guidelines. And the federal government tried sentencing guidelines in the past, and that really tied the hands of judges and it underscored or undermined the judicial discretion, which is most important. I have changed my mind. I've looked at somebody's criminal history, and the night before the sentencing, I now have decided what I was going to do based upon what I've seen in their record and what I've seen in their performance in front of me. I've changed my mind when I've listened to attorneys. I've changed my mind when I've listened to victims. And if you undermine judicial discretion, you're denying the role of a judge to make that decision. And those are difficult decisions. So I'm not in favor of the legislature mandating judicial sentencing at all.
Let's move on to our seventh question. And Mr. Wethington, you get the chance to answer this one. What are your views on alternative sentences for nonviolent offenders?
We have been, and I have been implementing in circuit court drug rehabilitation, mandatory drug and alcohol assessment. Shock probation is an alternative, is a form of alternative sentencing. Then there's a specific form of alternative sentencing to sentence someone to a misdemeanor time for a felony offense. Those provisions have been very successful in some people. They don't always work for someone. They don't always work, and I make mistakes about deciding on whether or not somebody should go to the penitentiary or whether they should not. I recall we had one governor who released prisoners from the penitentiary, and one of those individuals came back and within a month killed 2 people. So I'm not in favor of the legislature or the executive branch telling the judiciary what they need to do about sentencing. We use shock probation to give people a taste of the penitentiary, and that's been very effective for some people that really don't belong in the penitentiary but know they have to change their behavior.
Ms. Jackson, same question. Where do you stand on alternative sentences for nonviolent offenders?
I think that alternative sentencing is an important tool for circuit judges to use, especially with nonviolent offenders. As I said, there are statutorily violent sentences that we just cannot probate. Alternatively, there are individuals who maybe are in court because of something that has happened to them. They've had unaddressed trauma. They have an addiction issue. They have an unaddressed or unidentified mental health issue. And alternative sentencing gives judges the opportunity to order those individuals to seek those types of services in addition to or in lieu of being incarcerated. I think it's a useful tool to get individuals out of the jail and into programming that can help them to be successful, help them to heal, and help them ultimately to return to society more prepared to handle the struggles that they were facing when they became incarcerated and had their first contacts with the criminal justice system.
This is our final of our prepared questions, and after that we'll be giving you a chance to give your closing statements. Ms. Jackson, this is your question first. What do you perceive as the greatest obstacle right now to achieving justice?
Achieving justice. That's an interesting question. It depends on what you mean by achieving justice. My job as a circuit judge is to apply the law fairly based upon the facts of each case in front of me. I would rely heavily, of course, on the prosecutors or the plaintiff's attorneys in civil cases and the defense or respondent's attorneys to present all of the evidence to me. As far as the greatest hurdle to achieving justice, I'm uncertain how to answer that because I feel that I would rely heavily on the attorneys. They know their cases, they prepare their cases, they know the individuals that they represent. So simply relying on them, doing my research, relying on my experience in the trenches, I could just make the best decision that I could on each case.
Mr. Wethington, same question. The greatest impediment toward achieving justice today, and I base this on my experience of 25 plus years of doing jury trials, is that we used to have courtrooms full of watching trials, just spectators. And now many times when we have a trial, the only people there are the people who are interested, the victims or the families of the accused. The biggest hurdle is that people who come to court, they don't fully understand our justice system. They don't understand the electoral process. They don't understand that a person is innocent until proven guilty, and they don't understand that an accused has to have a trial and it has to be fair. That's been my experience with the biggest impediment on justice. However, justice is sometimes a community gets the justice it wants, and sometimes it gets the justice it deserves. It's a hard concept, but when you see justice in the courtroom, it's very clear.
That's the end of our prepared questions. We told you before we started, and now we're at that point in the session where you each get a chance to give us a 60-second closing statement. And Mr. Wethington, you'll get the first opportunity to give that closing statement.
The thing that I've witnessed in my experience as a prosecutor and as a judge is that we've all experienced the explosion of addiction in the nation and in our community. We are fortunate in Owensboro that regarding those rehabilitative processes that you asked about, we have a variety of addiction treatment centers. We have so many, we're blessed that we have many different approaches toward addiction, and that's been 85% of the criminal conduct in circuit court is dealing with people who are either addicted or stealing for addictions. And we have rehabilitation centers in Davis County, and we routinely and regularly rely on them to treat people because addiction happens to good people. They don't always belong in jail, but they need a wake-up call, and the assistance of those treatment centers has been very helpful to the court system.
Ms. Jackson?
I intend to continue to implement that.
Ms.
Thank you,
Jackson,
Jake.
your chance for a closing statement.
Yes, sir. Thank you for the opportunity to be here, first of all. While I don't have experience on the bench, I do have over 2 decades of experience in court daily. I frequently visit jails and less frequently prisons in the state, and I see what resources are offered through incarceration. I work closely with community programming, substance abuse and mental health programming, so that I know what opportunities are out there for individuals who need to address their mental health issues. I have seen the plague that addiction and mental illness has impacted on our community. I see how it brings people to the criminal justice system. Everyone who's in court has committed some sort of offense, whether it's a civil or criminal, that has brought them to the court system. But I have an understanding and know that those are issues that I have to consider on each case when making a decision what to do with those individuals.
Well, that ends this session. Thanks to everybody who took the time to watch here in person and at home, and thanks to each of the candidates for coming and joining us here in person today. We also want to thank the Bluegrass Music Hall of Fame and Museum for allowing us to use their facility, and also our sponsor, Jerry Ray Davis, Chrysler Dodge Jeep Ram. We'd like to let you know that Election Day, November 8th, just a few weeks away. Do not forget to vote no matter which candidate you're voting for. And thank you for watching our candidates, ladies and gentlemen, for Circuit Judge.